If you're stopped for suspicion of drunk driving, always be polite to the officer. I wouldn't make any admissions at all. Even, the standard thing in a police officer hears is, oh, I've had 2 beers. I wouldn't even make an admission that I've had anything to drink at all. Just politely tell them, look, I really don't want to talk to you without a lawyer present. If you need to write me a warning ticket, or if you need to, do X, Y, and Z, I just prefer to get around, go my own way. But be polite, don't answer any questions. Definitely don't offer any kind of information up that may be detrimental to your case. And once again, I would advise everyone not to do any kind of roadside field sobriety test at all. Refuse all tests except for when you get downtown. If you are arrested, do not refuse the breath test, but I would refuse everything but that, and that's going to be the most beneficial for your case. A lot of times the officer will ask you to take a roadside, what we call PBT, which stands for portable breath test. These are not admissible, and the police officer will tell you when they're asking you to take it, would you please take this test? The number doesn't come in court. And that's true. While the number doesn't come in court, what does come in is whether it's positive or negative for alcohol. Now, that can mean a lot of things. It can mean anything from a 0.01 to a 0.25, but still, just having that extra bit is obviously not going to be helpful to your case. We definitely see there was alcohol involved at that point. So by refusing everything, I think is just the best way to go, other than the breath test downtown. If you want to refuse the test, and be as respectful as you can to the officer, just tell the officer, I'm sorry, I don't feel comfortable doing these tests, especially without my attorney present, and I'm going to have to decline to do any of these. If you're arrested at a checkpoint, I love checkpoint cases. I love checkpoint cases because what most people don't understand is checkpoints are always unconstitutional without certain things being done. And there's a way to do it correctly so it can be constitutional, but so many officers just don't follow the things that they're supposed to follow to set them up properly. So many times I've won cases just because of the fact it's an unconstitutional checkpoint. Like I tell the judge, this ain't England. We're in the United States of America, and we have the freedom to move around as we like, unfettered, and not being questioned by the authorities. So there's a problem. Anytime there's a roadblock or checking station, that thing better be in check, because if it's not, I'm going to get into it and we're going to have an issue. In most checkpoint situations, it's going to be a fairly quick encounter. They're going to ask you to roll your window down, to usually give a license and registration, which they're going to look at. And the next question out of their mouth is usually, have you had anything to drink tonight? Once again, I think that any kind of admission is not a good thing. I'm not saying lie to the police, but at the same time, just refusing to answer any questions without a lawyer present is probably the best advice I could give someone in that situation. If you do refuse to answer any questions at a checkpoint, it doesn't necessarily mean that you'll get arrested. It just honestly depends on that officer and what they're, where they're at that night. If it's something where because they're always going to shine their light in your car, they're going to see who else is with you, or if you're by yourself. It's just going to be up to that officer's own subjective thought. The accuracy of field sobriety test is it's something that's just very questionable, because the types of clues that the officers are looking for are so subjective, given to each individual officer. Something that I might think's a clue, another officer might not. An example of that could be on the walk and turn test, where they have you walk the line. One of the clues would be that you have your arms, they call it using your arms for balance. So this would mean if either one of your arms comes more than 6 inches away from your side, they consider that using your arms for balance. 6 inches, yeah, it's subjective. Does that look like 6 inches to you? It might not look like 6 inches to me. So that's part of the subjectiveness. Another on that same test is, let's say that I'm doing the walk and turn test, and I miss heel to toe by more than a ½ inch. Now, no one's actually out there with a ruler as you're taking these steps measuring what a ½ inch is. Does it look like it's more than a ½ inch? Does it not look like it's more than a ½ inch? Once again, this is something that's subjective to each officer in the field. The experience that I have dealing with standardized field sobriety test is pretty vast, because I've taken the same classes the police officers have. I've taken the standard 40-hour class on the standardized field sobriety test. Then I went above and beyond that and taken the NHTSA A-RIDE class, which is Advanced Roadside Impairment, that deals more with drug-impaired driving. I've even done a DRE, which is Drug Recognition Expert portion. I didn't actually go through that whole school because that would take weeks to do, but I have all the training manuals, I have all the materials, I'm very well versed with them. Because of my familiarity with the standardized field sobriety test and the things that are done on the roadside, the results that I get sometimes are evident because of I'm able to pick apart what's done properly, what's done improperly, and paint a better picture for the judge or the jury depending on who the fact finder is in the case.